Welcome to our annual meeting. I am Chantal Stephens, and I have the distinct privilege of serving as the executive director of our affiliate. The team and I are thrilled to spend time with you today as passionate advocates for civil liberties across our great state. In our time together, we will reflect on the milestones we've achieved, challenges we've faced, and victories we've celebrated over the past year. Even as we celebrate the wins, both the big ones and the small ones, we acknowledge that the fight for civil liberties is ongoing. In this election year, our democracy is on the ballot. We are already seeing ramped up efforts to misinform and sow confusion among the public. We are seeing anti-democracy candidates who encourage violence as a tool to achieve political outcomes, win primaries, and put forward campaign platforms that seek to separate us and strip our neighbors, family members, and our friends of their dignity. In the face of these ongoing challenges, our resolve remains steadfast. We have created first-time voter toolkits to provide accurate information to the public. We are building out candidate questionnaires to identify where candidates stand on the civil rights and civil liberties issues in which we work. And we are partnering with other organizations to mobilize supporters, including those of you on the call with us today. We know that in partnership with you, we can and will continue to stand up for the marginalized, challenge injustice, and work tirelessly to create a more just and equitable North Carolina. Please be on the lookout over the next few days and weeks for more information, for links to events and opportunities for you to engage with the work. And now we are going to turn to our panel about the Racial Justice Act. And to lead us in the discussion is the very special Michele Delgado. Michele, will you please come up and join me in the spotlight?
Good morning, Chantal.
Awesome. So Michele has been a staff attorney with the ACLU of North Carolina for the last 2 years. Michele is an alumna of both North Carolina A&T and NCCU School of Law. She has a criminal defense background and an unwavering commitment to the fight for social justice. Michele works to address emerging and ongoing civil rights issues through complex litigation, community education, and integrated advocacy. In fact, Michele is the editor of the report exposing alarming racial disparities in school-based disorderly conduct complaints that I talked about earlier. So at this point, I'm going to hand the mic to Michele, and she will take it away from here.
Thank you, Chantal. Good morning, everyone. I want to thank you all for joining us today. This panel will focus on the Racial Justice Act. If you are not familiar with this act, no worries. We will hopefully answer a lot of your questions to help. And to help with those questions, we have a wonderful panel joining us. So if we can get our panelists on screen, Jeremy, Henderson, and I believe Noel. Yes. We're missing one more square. Can we get, there you go. All right, good morning. Let's kick this off with introductions. Can each member of the panel tell us your name and what you do? We can start off with Henderson and he could popcorn it to another panelist.
Good morning. Good morning, Michele. Henderson Hill. I'm with the Capital Punishment Project of the National ACLU. Noel?
Good morning, everyone. I'm Noel Nickle. I'm the Executive Director of the North Carolina Coalition for Alternatives to the Death Penalty, the statewide organization committed to ending the death penalty in North Carolina.
Good morning. Jeremy Collins here, CEO of Blackacres, which is an anti-racism, innovation and connectivity firm, and President of Providence Omnistructure, a nonprofit last mile broadband provider and connectivity provider to rural and underconnected communities. I'm excited to be with you all this morning.
Thank you. And we are very excited to have all three of you with this morning. Let's kick this off with just the basics. Jeremy, can you explain what is the North Carolina Racial Justice Act?
Thank you. So thanks for having me, Michele. And I might be the least qualified person to answer this question, but essentially the Racial Justice Act, beyond just the letter of the law, is really a response by practitioners and directly affected people on what could be done to alleviate the most egregious form or the most egregious action in our criminal justice system, our state's criminal justice system. Lawyers and advocates and organizers and kind of market players sat down back in 2006 and 2007. Many of those conversations happened at the ACLU at Replacements Limited, and place where you all have where you used to have your annual meetings to decide, what could we do to help our clients. And RJA essentially allowed criminal defendants to challenge the decision to both seek and apply the death penalty in North Carolina. At that time, a criminal defendant could raise an RJA claim at a Rule 24 hearing after decision to convict someone capitally, or once a decision was made to execute someone, a defendant could raise an RJA claim, allowing them to introduce statistical evidence or real evidence to challenge both the prosecutor's decision, the jury's decision, or the ultimate attempt to execute them.
Thank you. And just keeping this informal, so if any other panelists like to hop in on any of the questions I direct to anyone, feel free. So essentially, the Racial Justice Act is for people who are on death row to seek relief on their sentence if they're able to show some sort of discrimination in whether the prosecutor's decision to seek the death penalty, or if there was any kind of prosecutor discrimination in jury selection. That is essentially what the Racial Justice Act is for, right?
Right.
So my understanding is that—
Yeah, Michelle, let me interrupt you. Jeremy said he's the least qualified to talk about the Racial Justice Act, but he was there ground zero when we were passing the legislation. Jeremy was aware of the historic nature of this legislation, which was answering the challenge that was laid down in McCleskey, that although we could look at the operations of the court system and look at the operation of the death penalty and see that it was discriminatory, the federal courts were not going to have any part of that. And so they said that was something that was left to the state court system. The states were the laboratories for that kind of criminal justice reform. And Jeremy led the effort along with ACLU support, the coalition partners of CDPL. We led that historic effort. And so don't let that humility get in the way of what his acts and what the fruits of his actions were.
So Jeremy, you're being modest with us today.
Well, yeah, it was certainly a team effort, and I happened to be the person that was kind of liaising between the coalition, this strong coalition across North Carolina. I love talking about kind of the inside-outside strategy that we had, and then working with the members in the legislature. ACLU lobbyists at that time, Sarah Preston, Chris Parks, and I, and many others. It was and then you had community coalitions. I know that there was a Charlotte coalition, the Gaston County Moratorium Coalition. There were folks in Asheville. Noel, was working with the groups of folks that were in Asheville. There were folks all across the state, from Murphy to Manio, really helping to make this happen, and informed by both our clients and the people, representing folks in the courts. So it was a Herculean effort by a lot of people.
I'm sure it was. This is such an important act that at some point passed, but from my understanding now, it was repealed back in 2013. Can you talk about the impact that had?
Well, yeah, I mean, I think that and I'll speak to part of this, and I'm sure the other panelists will have perspectives. But Henderson referenced the response here, like kind of the federal courts punting to the state courts. I want to go back even farther to 1987. Well, at that time, you know, the McCleskey versus Kemp decision, where the court acknowledges, you know, racial bias in the application of the death penalty, and then, you know, after having built essentially the evidence of this, Professor Baldus, in that initial race study, the court essentially says, however, like, to solve this issue, we would have to dismantle the entire criminal justice system. Therefore, Mr. McCleskey can just be essentially can just be executed. And that, to me, is essentially what the legislature and what the courts did in 2013. Like, in the face of all this evidence, it's not like we did a study and, you know, there was no merit for RJA. If anything, we showed the kind of what we say in the country, the bald naked truth of what, you know, criminal or essentially capital prosecutions mean in communities. So it was a gut punch, but it was also kind of like, you know, it was a re-entrenchment of white supremacy. And that is, you know, it's actually, we spend a lot of time talking about what fairness is and what justice is and how we can make the system less unfair. And the response from the legislature was, we're not concerned with making the system less unfair. We're not concerned with encouraging people. I heard Liz in the last discussion talking about getting people out to vote. All these things, when you can look in the face of truth and choose a lie, all these things function to disenfranchise people from being constructive, productive, civically engaged community members. It's the type of activity that throws a fire blanket on building strong communities. And I'll yield to other folks.
Mhm. Well, I want to get Noel into this conversation. So Noel, can you explain the current state of the death penalty and specifically death row in North Carolina?
Sure. And thank you so much for the invitation to be with y'all this morning. To be here with Jeremy and Henderson is quite an honor. And to just acknowledge that ACLU North Carolina and the ACLU Capital Punishment Project are two of our very important coalition members of the 24 partner organizations that we have. And I think it's a great segue because the impact of the Racial Justice Act is that we haven't had execution since 2006. Due to the incredible work of the folks that Jeremy named and Henderson and so many others. So RJA, even though it was repealed, there are still, I think, about 120 pending RJA claims of the 136 people sentenced to death in North Carolina. And because we haven't had an execution in 2006, I like to say it's out of sight and out of, well, I don't like to say it, but it's the truth, that it's out of sight and out of mind for so many North Carolinians. And I think it's really important for us to just keep saying we do have the death penalty, even though thankfully we are not executing people in North Carolina. We're the 5th largest death row in the country. And the systemic racism of it, which I know we're going to talk about related to the RJA, is just undeniable. So 60% of our death row is made up of people of color, and you compare that to the 30% demographic in our state. We've had 12 people exonerated from death row. 11 of them are men of color. More than half the people on our death row were sentenced by an all-white or nearly all-white jury, which is, you know, what the RJA is about. And then another data point that I often mention to people is that if you are facing a capital trial in North Carolina and the victim of the homicide is white, you're 2 to 3 times more likely to be sentenced to death than if that victim is a person of color. All those data points are on our website, nccadp.org, but I think we just have to keep saying it. You know, just a solid conversation with the general public, because people really do not appreciate the fact that we still have a death sentence that's active in our state. Last year, there was, I think, at least 1 death sentence. I think there are 24 pending cases for 2024. Now, a good number of them will plead out, But as long as we have the death penalty, those pleas are far more excessive in sentencing. And it's also disproportionately applied. So if you look on our website, we have a map, and you'll see that some particular counties, one of which was named earlier, Wake County disproportionately sentences people to death, as does Forsyth County. So the injustice of it is just undeniable. And there are 136 people that could likely face execution if we do not take considerable steps to prevent that.
And just to emphasize to the audience, the website that Noel mentioned is in the chat, so please check that out. Noel, so would you say that the RJA is a substantial step towards fighting against the death penalty and death row?
Oh, absolutely. Yeah, I mean, it's the RJA and its lethal injection litigation that have prevented executions for the last 17 and a half years. But as Henderson will be able to address, I'm sure, we're somewhat confident that RJA may eventually fall away. And now that Alabama, is more than willing to tell people how to use hydrogen gas for execution methods, then that's the sense of urgency that we face, particularly for 2024.
Thank you. So since we're here to talk about the RJA, let's talk about what's going on right now, right? This year, the ACLU of North Carolina, the ACLU's Capital Punishment Project, NAACP's Legal Defense Fund, the Center for Death Penalty Litigation, and along with private attorneys such as Jay Ferguson, have all joined forces to represent a man named Mr. Hassan Bacote. Mr. Bacote is a Black man from Johnston County who is challenging his death sentence under the Racial Justice Act. On February 26th in Smithfield, an evidentiary hearing began in Mr. Bacote's case. Mr. Henderson here is very knowledgeable what happened there. I was there and he did such a great job. Henderson, can you talk about why is Mr. Bacote's case significant?
Thank you, Michelle. And Michelle, it's been great working with you in the lead up to the hearing and at the hearing. I think we're all proud of the presentation of evidence from our partner organizations and institutions. And it's so important because in 2020, former Chief Justice Sherry Beasley identified the history in North Carolina and throughout the country of courts being complicit with race discrimination happening right before its eyes, through sort of ignoring practices and techniques that excluded Black citizens from participation in juries, practices and policies that led to the disproportionate targeting of Black males in particular for capital prosecution. So that challenge was laid bare in public statements by Chief Justice Beasley and in the decision in 2020 to find that the repeal was unconstitutional as to the 150-odd petitioners who had already filed under the act. So what happened in Smithfield was so important because we had 2 weeks of evidentiary hearings where we presented the testimony of leading national experts on statistics, social science, history. And what it did was it bolstered what we all knew before we passed the legislation, anecdotally, that race played an undue factor in jury selection. Well, we had the MSU study presented demonstrating that Black citizens were struck at twice the rate of their white neighbors. In Mr. Bacote's case, they were struck at 3 times the rate of their white citizens, and that this was not a fluke was laid bare by the evidence of the prosecutor who was responsible for putting Mr. Bacote on the roll. That man, in his cases, not only in Johnson County, but in other jurisdictions, struck Black citizens at a rate 10 times that of their white citizens. This is what we're talking about when we say that race was used to exclude Black citizens from the full franchise. That is the full participation in the democratic process. We had testimony from Crystal Sanders, an Emory history professor, but more importantly, a native daughter of Johnson County. Her ancestors were enslaved in the plantations in Johnson County. Her father was targeted as one of those citizens that were used to integrate the previously all-white schools and bore the brunt of that integration by intimidation and violence directed to him. She saw, well, actually, she was prevented from seeing Klan marches because her dad kept her from going to civic celebrations where the Klan would be marching. She was a valedictorian of her high school class who the principal refused for the very first time not to issue a medallion to recognize that achievement. Yeah, so this young history professor could come and give voice to what the community in Johnson County had been laboring on for decades, really for a century. And so it was a remarkable experience. I'll say this, that the fact that the hearings were live streamed enabled community members to watch without fear of reprisal. Yeah, we had some family members, some community members show up and show support, but many more could follow and track the proceedings in the safety of their own homes without fear of retribution. So yeah, it's a remarkable proceeding. We look forward to bringing it to conclusion. We've got a litigation schedule planned. It will probably end with closing arguments in May. And then that record will eventually go up to the state Supreme Court, where we've got reasons to be concerned. And I think the ACLU affiliate, National ACLU, all of our partner organizations need to be thinking about and strategizing with Noel about how we respond to what we anticipate a hostile reaction from the current state Supreme Court. I know that Noel and Jeremy will have thoughts on that. It's a difficult position for lawyers, particularly lawyer of record, to talk about some of the concerns we have about how this appellate process proceeds. But both Noel and Jeremy are really keen observers of the litigation in the state and the political realities of the state, and will have much to add to how we act and respond to those concerns.
Henderson, during Mr. Bacot's evidentiary hearing, there was remarkable evidence regarding the KKK, their marches, the billboards. Can you speak a little bit about that, and why was it appropriate to consider this type of historical evidence in this way?
Well, it was appropriate because Johnson County and Smithfield took some pride in their suppression of the Black community for decades. All through the 20th century, the billboards that were erected and remained at the entry on Route 70 as you're going into Smithfield, as you cross the Neuse River, that was really the welcome of any citizen into Smithfield. And it claimed for itself Smithfield as Klan country. Love it or leave it. You know, enjoying the fight against integration. This is what every juror coming from Clayton to the Johnson County courthouse had to see as they were responding to juror summons. So when they walked into a courtroom, into a courthouse that had never had a Superior Court judge, never had a district court judge, never had a magistrate judge, never had a district attorney who was Black, and they saw that logo, that was a reminder that, yeah, this is the seat of white supremacy in North Carolina. And so, Crystal Sanders recalled that in the post-war period, when Black folks were agitating for the vote, the response of the all-white courthouse was simply to close the doors. The clerks simply didn't have office hours that were available for Black people. They would sit and wait, and there was no clerk there. White citizens, on the other hand, were able to find private arrangements to register for vote. When in 1958, the first Black police officers were hired in Smithfield, they were said, Well, you can't patrol in the white neighborhoods. You can't arrest white folks. You're limited to calling disturbances in the Black community. Well, it's that notion that there's a different justice available to Black citizens than there are to white citizens is what that Klan billboard symbolized. It reflected that power of white supremacy. And I'll just throw this one anecdote that came out at the hearing. In 1986, Ellis King was shot by a Smithfield police officer in his parents' home. If that didn't sound like the actions of the KKK, I don't know what was. A passing Black citizen saw and heard the conversation where the police officer, having Mr. King subdued, turned to his partner and said, "Should I shoot him?" He shot him. One shot to the head, he's killed. None of the police officers were held accountable. One was promoted to magistrate. One was given a job with the General Assembly Police. One was hired by private business in Smithfield. That notion of unaccountability for racial terrorism, for racial violence, is one that lives on in Johnson County. And hopefully this litigation has shown the light on that, and that we'll get some relief. Yeah, I have some confidence that the record, both statistical, history, and anecdotal, we didn't mention the fact that part of what we did in this litigation was unearth the comments of prosecutors in their jury charts, in their jury notes, that showed a preoccupation with the race of the prospective jurors, that showed the use of tropes and stereotypes in their assessment of Black citizens reporting for jury service. It was eye-opening. It was shameful. And hopefully the record will be such that even this state Supreme Court will acknowledge it and follow the law.
It really was a truly eye-opening evidentiary hearing. The Racial Justice Act is going to be huge here in North Carolina, especially when people really sit down and talk more about what happened in Smithfield. For Jeremy and Noel, what steps can people take to support the RJA in the death penalty abolition movement in North Carolina?
Noel, you want to go first?
Well, I can, but I'd love to back up a little bit too and just talk about other efforts that it is in companionship with. We're really focusing on decreasing death sentences because we know we don't have the opportunity for full abolition, death penalty repeal with our General Assembly, even though a bill is introduced every session. We've referenced the tenor and tone of our state Supreme Court, so we don't have relief in that regard as well. And so another key effort right now is asking Governor Roy Cooper to commute all death sentences before he leaves office. And there's a lot of information about our campaign on the website. And primarily, we are trying to help empower and give voice to all North Carolinians right now to let Governor Cooper know that the death penalty is racist, and to certainly highlight all that Henderson just shared. The hearing was so incredibly powerful and unfortunately eye-opening. I mean, how did we not know this? Well, we didn't know it because it's racist and because white supremacy still rules in our courtrooms in North Carolina, and particularly when the death penalty is at play. So really calling on Governor Cooper to honor what we believe is the legacy that he wants to leave of being a leader in racial justice. It's in keeping with the Task Force for Racial Equity, which Henderson could also speak about. It's in keeping with Governor Cooper forming the Office for Violence Prevention. All of this is the legacy that we believe that he would like to leave. So we currently have a postcard campaign. We anticipate launching a billboard campaign pretty soon, but really calling on Cooper to take this bold step. And we're hopeful that he will. And when the closing arguments happen for RJA, we'll want to pack the court, just as we did for the opening day. And I just want to give a huge shout out to the legal team. It was an incredible 2 weeks. And to invite folks to join us when that closing argument date does happen, Henderson said May. I was hoping maybe late April. We don't know. But if you sign up for our email, you will know. And we'll be sure and let you know well in advance and keep you updated on that. Yeah, I think that's what I'm thinking of right now. There may be some other things, but I'll pass to Jeremy as well.
Yeah, thank you, Noel. I would say, you know, from a moral perspective, I want to back up even farther and say that this is actually a struggle between whiteness and white supremacy. Those people sat home, as Henderson described, and were afraid to go to that courtroom because, yes, white supremacy is at play here, but there's a certain complicit, whiteness that happens even in spaces where, you might not see the brutality of white supremacy, but just the status quo of whiteness. I remind our colleagues about this. Sometimes we do have a very dangerous and bombastic Republican GOP nominee for governor of North Carolina. But unfortunately, the Democratic nominee, Josh Stein, is no friend of RJA. And that's unfortunate. And that's sad. And that's the thing that we don't talk about enough in this circle. It would be irresponsible for us to just try to get Black people out to vote. Every time there's an election, we talk about, what's the base going to do? Are we going to get Black people out to vote? If our candidates are going to win, Black people can't stay at home. But we don't spend any time talking about candidate accountability. If you want people to be inspired and to be encouraged to be civically engaged, then we got to do something about complicit candidates or the brutal the candidates that espouse brutality. So I would say on a moral level and on a community level, we need to be holding our candidates accountable. We need to be having more conversations about what our values are. We need to be having more conversations about why does this legacy of white supremacy linger very strongly in Johnston County and in neighboring Harnett County and all across Eastern North Carolina. I'm in Martin County right now, which is, Judge Sermons sits on the bench here in Martin County. We need to be asking ourselves, this is not just all the sheet wearing white supremacists. These are some complicit James Crow lawyers and advocates and doctors and people who you might see in all walks of life, particularly evangelical Christian pastors. And we need to be having this conversation about what it is that what our values are, what it is that we're willing to accommodate. And if we're truly going to be an equitable society, if we're going to truly be a society that lives in love with each other, with all of our neighbors, then we have to disavow white supremacy. We have to disavow this binary narrative of whiteness versus white supremacy, and live out a greater truth, which is love of neighbor, love of all of us. And I think that's a thing that happens every day in our barbershops, in our grocery stores, in our places of worship. I heard someone say that the places where we, live, eat, work, and pray, right? We have to be having that conversation in every space. That's what changes the outcome of our elections. That's what changes the way our courts dispose of cases. That's what changes actually the people who come through our criminal justice system. If we want to, lessen convictions and lessen violence and build more love, then we have to model that every day. So I would challenge us to think beyond, the transactional, right? Of contact this person, do this thing. We need that. That's absolutely important. I will be doing that thing. I show up at the vigils. I come to the campaigns, the letter writing campaigns, or the vigils at the mansion. We need everybody doing that, and we also need to be talking with our white friends to say, this is not just about getting Black people or brown people out to vote. You got to have some difficult conversations, both in private and in public. And y'all got to fix this because we not showing Black people and brown people are not afraid to come to Johnston County Court. just because of the KKK and because we're lazy. Like there's a working majority apparatus here, and we got to address that fully head on.
Well said, Jeremy.
Absolutely. Thank you so much for naming all of that, Jeremy. I would just add the importance of centering the voices of people most impacted by this system too. And so we're really fortunate, for example, to have family members who have lost loved ones to homicide, who show up time and time again, who launched our commutation campaign, who traveled across the state to try to get our JA passed originally. So those voices really lead us as well. But challenging the whiteness, I couldn't have said it better, of course. Thank you, Jeremy.
I couldn't have said it better either. Thank you, Jeremy. I know that the commutations campaign was mentioned. I want to highlight that the link is now in the chat. So if our attendees can check that out, that'd be great. I want to go ahead and open the floor to the Q&A. We have a couple questions for the panelists. So I'm going to go ahead and read those, and feel free to pop in and answer, okay? First one. I know that we don't know the dates for closing arguments right now. Let's hope for end of April, but if not in May. The question is, for packing the court, can you say more about why that matters?
I have an answer, and Jeremy, but certainly Henderson may have a different answer, or at least an additional answer. But we want everyone to know that this case matters, and that there are eyes on the systemic racism of the death penalty. And there are lots of ways that can be communicated, but it also supports Mr. Bacote. I know personally from hearing from him that it means something to him to have people there. And I think it means something to the people of Smithfield as well.
I would add that this is participatory justice. And if you want, civic engagement is not just voting. It is, as Henderson and others argued in the evidentiary hearing, it is the ability to sit on a jury. It is also the liberty and the freedom to be able to sit in a courtroom and watch how justice is administered, particularly to people who look like you. But I would make the argument, well, I want Black people and brown people to bear witness of this. I want an overflowing courtroom of white people, like because sometimes this type of injustice happens in silence and in solitude and in a silo, and everybody doesn't see it. But I want Judge Sermons, and I want AG Stein, and I want those actors to be able to turn around and say, like, pardon my French, holy shit, there's so many people here that their eyeballs are on us, and the world is watching. And I'm not saying that I think all of us wake up to do this work every day because we believe that, like, it makes a difference. And the legislature or the courts might try to convince us otherwise, but I think it's important to pack the room so that the people making decisions can tell that this is important, and that there are consequences to choosing against justice. That's what I'm thinking.
And Jeremy speaks about this moral plane so well. And it has real meaning in Johnson County, where just a year or two ago, they held the budget of the school system hostage until the superintendent was forced to sign a pledge not to teach critical race theory. And what that really was a pledge not to teach history, not to be truthful about history. And what the RJA does quite frontally is say history matters. What Justice Kavanaugh said in applying or trying to analyze the impact of Batson, he said history and math are critical. The math of 12 boxes, 12 seats in the box, and 14 peremptory challenges. How you get Black people off the bench, off the box, out of the box is a matter of math. Why they do it is a matter of history. So when I see community members represented in the courthouse, in the courtroom, it encourages me as a civil rights lawyer, as an abolitionist, to know that we're speaking with and for the community, and that the community is reflecting and responding and supporting that. And the hope is more members of the community will feel more encouraged, more emboldened to show their support. And, Judge Sermons is an elected politician. The the judges on the Supreme Court are elected politicians. And so while the winds of anti-wokeness are blowing hard in one political party, I think when you lift up this essential truth, and if as Jeremy is encouraging, showing the sort of interaction between whiteness and white supremacy, even people who are on the opposite ends of the political spectrum might find a point at which they say, this is intolerable. Remember, Justice Kavanaugh and Chief Justice Roberts, they have found individual data points on Batson analysis where they say, oh, we can't go this far. In Foster, we can't go this far. We can't say that Blackness, race itself, is an aggravating factor in a capital sentencing decision. No, that goes too far. The sixth prosecution of Curtis Flowers, yeah, that's too far. So this is why I think it's completely a high priority that we give maximum amplification of what's going on in Johnson County, and we get as much community support involvement in that litigation, and that the governor, the attorney general, and the court sees this bubbling up from the community for equity and racial justice.
I think I'll add one more thing. I hope I'm not, stepping out of line here, but Noel mentioned something, and Henderson just touched on it as well. RJA didn't happen, as a flash in a pan. I mean, there was the lethal injection litigation that happened just subsequent to the Samuel Flippin execution, which was kind of the start of no further executions in North Carolina. But there was also this interplay of doctors not being able to participate in execution. The North Carolina Medical Board said it would punish any doctor that was participating in execution. And then you've got these other bills that are introduced in the legislature in the prior and same session as RJA in 2008, and then again in 2009. So if we fast forward to today, there's a tie between what you're seeing around this DEI attack and RJA. Now, on one hand, you can make the argument that I thought DEI was about diversity, equity, and inclusion, and that includes people with developmental disabilities, women, and any person from a marginalized community. But what we know culturally is that when you see these attacks on DEI, they're really just talking about race. This is an attack on racial equity. They're not thinking about diversity and equity and inclusion in other spaces. And so if we want to build a trend, a narrative, a culture, a consciousness that says that we are concerned and committed to these things, if you want to see an RJA, if you want to see a strong RJA, then we also have to be fighting for DEI. We also have to be fighting for initiatives that seek to level the playing field, not just about criminal justice, because we're not going to be able to harm people in housing and education and employment and economic opportunity, but we're going to do justice over here in the criminal justice system. All these things have to matter, and we have to work for them all in concert.
Mm-hmm. Absolutely. Following up on the Pack the Courts question, one of our attendees would like to know, is there a typical time of day or day of the week where the closing arguments will occur? I think Noel, you would like to answer that?
Well, I'll confess, I thought I was just going to type an answer because it's pretty straightforward, but I messed that part up. So yes, I'll answer it. And Henderson, correct me if I'm wrong, please, but we actually will know the date probably 2 weeks in advance. Judge Sermons laid it out pretty clearly that the defense, both sides, would have a chance to prepare closing arguments after the official court transcript is complete. And to my knowledge, that hasn't happened yet. So we're at least still two weeks out. What we don't know, and it will be convened as a hearing, likely starting at 9:30 or 10 in the morning on a weekday. What we don't know, and Henderson, please again jump in. We don't know when Judge Sermons will issue his decision, and that likely will be sometime this summer. But we don't know that, and we will need to be prepared for whenever that happens.
Yeah, I think Noel has it as close to right as anyone can predict at this time. Judges enjoy the discretion. Yeah, they set the calendar. Once arguments are complete, it's really up to them to deliberate. The Judge Sermons will have the benefit of a proposed order from the state and a proposed order from our side. Yeah, we think our experts were extraordinary teachers. And so although the science was complicated, the statistics were complicated, we had 3 university professors who were super skilled instructors and teachers explain this stuff. And we had extraordinary social science and historian experts whose testimony was compelling and clear and accessible. So we believe that while it's complicated stuff, it was laid out very nicely at the hearing. We expect the briefing will give the court additional guidance. And my guess is a decision in the summer is very realistic.
Makes sense. So there's a question related to bats, and I know we've mentioned that a lot here. The question is, the Supreme Court bats a decision which found it unconstitutional to strike Black jurors based on their race. Prosecutors are trained to conjure up false narrative questions and defend them as a non-race reason. These are tactics that they usually use, and that allows for Black defendants to typically end up on death row being convicted by white jurors, all white juries. And so the question is, what action can be done to train our defense lawyers to win Batson challenges and to raise Batson aggressively?
Yeah, that question reminds me of some questioning at the oral argument on the Racial Justice Act 2 or 3 years ago, where I think it was Justice Earls asked the AG representative, can we just sort of do away with these things like procedural default and plain error and harmless error and just say, well, discrimination is wrong, it's bad. And as prosecutors, we want to encourage good, and we want to encourage fair access to the jury box. Can't we just agree to go and do the right thing? And there was some part of Brian Stevenson's testimony that returned to this notion that as prosecutors, they ought to be pursuing justice and pursuing good. And shouldn't we have prosecutors trained to make the jury box more inclusive and representative of the community? And instead, what we have is this complicity between the legislature, which when they saw the result of the Voting Rights Act, meaning Black folks were now on the voting rolls, and if they're on the voting rolls, then they're on the registration for jury service. And so you're getting Black people in the pool. And in response, in 1977, the General Assembly close to doubled the historic number of peremptory challenges available to prosecutors to 14. And that's where the Kavanaugh thing about history and math comes in. If you got 12 seats to fill and you're giving the prosecutor 14 free challenges, the math suggests you're going to get more and more all white or nearly all white jurors. And the history suggests that prosecutors are going to be inclined and disposed to use those challenges to whiten the jury box. Well, yeah, so that question really hits to that moral piece that Justice Earls tapped, and that Brian Stevenson tapped. Let's get rid of this Top Gun training, 10 best ways to avoid Batson. Let's just try to make the jury box representative of the community. Isn't that what we should do as lawyers and as prosecutors? We're still waiting for that response from state prosecutors. They haven't taken up that invitation as of yet.
They're taking a knee. They took a knee. They took a knee.
All right, we have another audience question. For death penalty capital cases, are you analyzing current applications of capital cases and identifying judges and prosecutors who are driving unjust applications and raise awareness of their actions? Is that clear? Yeah.
Well, the cases are ongoing. They're continuing. We've seen some progress in that the number of prosecutions are reduced, and that's a good thing. I think the challenge comes, and I think Mr. Butler, the prosecutor, exemplified this in his testimony. He talked about thug and animals of the beasts of the African plain and these tropes, and he said, well, they could have a racist intent, but it wasn't my thought. That's not why I use those words. And part of what he betrayed was when you get into the courtroom, it's a competitive environment. You want to win. And so it's not racial animus. It's just the desire to prevail. And that's what I have. I want to prevail on behalf of the victim families that I represent. And so the toxic thing that we still confront is prosecutors not recognizing their higher calling, and justifying the use of these stereotypes as what they need to win in a competitive adversarial system. And I thought what Dr. Summers said so well was, we're not looking for racial animus anymore. The RJA isn't looking for racial animus. So in the cases that are going through today in 2024, we don't expect the prosecutors to be the Bull Connors of old. But if they are comfortable securing what they believe is a competitive advantage in the adversarial system and use the math as just another technique of prevailing and winning and scoring points, well, then what Kavanaugh says about history and math conspiring to prevent Black citizens from having their full measure of participation in the democratic process, that ain't never going to change. So we're looking in 2024 for prosecutors to look towards their higher calling and not to hide behind the shield of simply exercising professional judgment to secure a competitive advantage in the adversarial space that is the courtroom.
If I may add, I think a part of that answer also could include just educating the general public about attorney prosecutorial discretion. And so the map that I referenced that's on our website that just shows very clearly which district attorneys continue to pursue death sentences and which do not. And some of those counties are adjoining, for example, Wake and Durham. And to just educate folks about how significant that choice is, and for people to continue to advocate in terms of not only who do they put in that position of power, but even when there is a case that could be determined capitally and pursued all the way through to trial, or to encourage a district attorney, we don't need this to keep us safe.
Thank you for that. I'm glad that we're talking about these important issues because there needs to be more discussion about what's going on, right? Like I believe that people see the issues we're having in court, but they don't have like the language or the words or the understanding behind the systemic issue of how is this all happening. So I just really want to thank you all for being here to really like break that down, talk about it, explain the Racial Justice Act. I believe some of our attendees today never heard of it or understood what it actually is. So thank you for joining us, truly. And I believe it is about the time I need to wrap up. So I do want to thank our attendees for also joining us. I hope that you all have enjoyed yourself here, have learned something. If you have any additional questions, please email us. We'll do our best to answer those questions. And again, please check out the links in the chat. That's my time, so I guess I'll go. Thank you all.
Good
Thank
being-
you, Michele.
Thank you. Thank you very much.
Thank you so much.
Henderson, Noel, Jeremy, and Michele, that was really powerful. Thank you all for taking the time to explain the Racial Justice Act to us, the racist roots of the death penalty, and the opportunity we now have to challenge and hold accountable systems that were designed to oppress marginalized communities. We put the North Carolina Coalition for Alternatives to Death Penalty's website in the chat for you earlier, but we can drop it again for you now. Don't forget, that's where you can learn more about the commutation campaign Noel talked about. And over the next couple of weeks, we will also send you information once we have it about that hearing, so that you can go and show up and help pack the court. So our time together is ended. But before we log off, thank you so much for joining us today. I encourage you to continue supporting the ACLU of North Carolina by keeping your membership current. If you're not already a member, please consider joining today by visiting our website. If you use social media, please stay informed about civil rights issues in North Carolina by following us on all social media channels. If you are not on social media, you can still stay up to date about our ongoing cases or learn how to attend hearings or rallies through our website as well. As we get closer to the start of the legislative season, please be on the lookout for opportunities to contact your legislators, sign petitions, or participate in grassroots advocacy campaigns to address ongoing challenges to our civil liberties. We will be following up after this meeting via email to invite you to volunteer your time in upcoming events. However, if you have financial treasures but not a lot of spare time, we invite you to donate to support our efforts in advancing civil liberties. And lastly, but dare I say probably most importantly, as you've heard from several of our speakers today, vote, vote, vote in the upcoming elections. As we know, voting is the fundamental pillar of our democracy. I know every single one of us on the call today will exercise that right to vote for candidates who support civil rights and civil liberties, but I hope we can also commit to being vocal about encouraging others to show up as well. Thank you again for coming. Have a wonderful Saturday.